The department issued its first charges in 2016 against the abuser, and in 2018 opened a formal investigation into the conduct of MSU at the request of and with a pledge of full support from the Board of Trustees. When I took office in 2019, I pledged that we would continue the investigation, be transparent about our findings, and be aggressive in this endeavor. At that point, the MSU board had released over 100,000 documents, but withheld approximately 6,000 of them under the claim of attorney-client privilege. I renewed my predecessor's request for the entirety of their documents again in January 2019, and multiple times, both formally and through the press, before being forced to close the investigation in 2021 due to the lack of cooperation from the MSU Board of Trustees. In 2023, upon the election of many new members to the board, and with information that this new board would vote in favor of releasing the documents, I renewed that request. Several days later, the board once again declined to share the withheld documents. But later that year, in December, the board finally voted to release the documents, and in March of this year, we began to receive the first batch of them. We do believe that we are now in possession of all the existing documents MSU has on this matter. Unfortunately, from the remaining documents, we have learned that not all of the communications were preserved, and that the university wrongly applied attorney-client privilege to many, if not most, of the remaining documents. Sorry, guys, I'm going to pause again because of the talking. Thank you. MSU has repeatedly justified withholding the documents because they contained information that was allegedly protected by the attorney-client privilege. Our review has revealed that this justification was not always appropriate. A significant number, if not a majority, of the documents did not appear to us to be covered by that privilege at all. Accordingly, there was no justification, no justifiable reason to withhold those documents for any period of time, let alone an extended period. Further, the documents that contained, or at least arguably contained, privileged information did not offer any new insight into MSU's handling of the abuse or who knew what about it and when. Indeed, most of the privileged information was not even related to those issues, but instead really to tangential issues such as public relations, insurance, and funding. Because our review revealed no new relevant information, we are closing this investigation. And while this closure is in keeping with the parameters of our investigatory duties, we recognize that it does not provide the type of closure sought by the survivors of Nassar's abuse.
Over the top of this graphic, I don't know if we should just post this and just leave it alone.
Just asking that the news outlets that are on right now, I understand that this is a different format than we usually use for technological reasons, but I think it's discourteous to people who are trying to pay attention to this. So I ask, please, that if you are a news outlet and you're on, that you mute this. And to my staff, I ask that maybe you remove those folks if they are going to continue to talk.
Unfortunately, AG, it's showing everyone is muted, so I can't see who the discourteous outlet currently is. But again, if you are recording this for yourself and for others, and you are allowing your background noise to be heard, you are ruining the recording for everyone.
All right, I'll continue. Sadly, there simply is no fulfilling the answer to the question of how Nassar was able to perpetuate his abuse on so many for so long without MSU or anyone else putting a stop to it. To say that I am disappointed in this outcome is really an understatement. While we begin each investigation in pursuit of the truth and facts first and foremost, and take criminal or civil charges as a secondary consideration, it is my belief that by withholding the remaining 6,000 documents, MSU unnecessarily prolonged that hope that the questions survivors had would be answered and denied them closure that they were entitled to many years ago. I'd now like to address the many, many survivors of this abuse. I commend you all for your bravery in coming forward and sharing your stories, and for never giving up in the pursuit of justice and transparency. And while the investigation is closed, this is not where this story ends. Never in our collective many years as prosecutors have we seen a group of survivors come together and create the sisterhood as you have and impacted systemic changes, not just here in Michigan, but nationwide, to ensure that schools are better prepared to prevent, investigate, and stop abuse, and to ensure that survivors are believed, are treated better in the judicial system, and to change the culture in how sexual assault is seen by the public at large. Here in Michigan, many laws have changed in response to your tenacious advocacy. Athletic trainers and physical therapists are now mandatory reporters. There is increased education in schools surrounding the prevention of sexual violence. Michigan has codified consequences for medical professionals who use their positions of authority to abuse others or prevent schools from reporting abuse. Criminal sexual conduct in the second and third degree are now, their statute of limitations have changed considerably from where they were before. And they're up now to from 10 years to 15 years. And the statute of limitations was revised for the civil suits that were related to this abuse. So culturally, you have certainly had a profound impact. And because of your work, we now recognize those who have been subjected to abuse as survivors are known as survivors, not as victims. You've changed how survivors are treated when they come forward, and you've changed our culture to one that leads with believing survivors. And you've allowed prosecutors across the nation to reform court testimony and allow non-charged victims to testify during sentencing proceedings.
For me, church, we would just like hang out in the kids' room.
I'm sorry, guys. I'm really trying to get through this. I wonder if there's a way just to sort of remove everybody so I can complete this. And then maybe people can email in or something. I'd really like to get this messaging across. It's just so distracting with everybody talking on here.
Being on TV.
It looks like it's NBC Universal. Maggie Vespa, I am removing you.
No, I was
From the
just
meeting.
unmuting to ask if it's possibly on your end because everyone else has been muted this whole time. That was an intentional unmute just to offer that possibility.
No, it is not. AG was the only one unmuted. And it is clearly, very clearly the sound of a newsroom. I'm going to mute everyone again, see if it goes away.
It was weird. Well, I'm not done letting talk.
Okay, go get lunch. Bye.
All
right, I'm going to go ahead and complete this. I'm sorry this has been such a distraction because obviously this is pretty important material that we're discussing. But I want to say in addition, nationally, the United States Association of Gymnastics has created Safe Sport to protect athletes from all forms of harassment and abuse, and campuses are reviewing their policies and procedures to better prevent, identify, and prosecute abuse, as well as bolster campus safety and crime data reporting. So it was your tireless work and advocacy that accomplished this, and your strength has left this world a better place for preventing sexual assaults and protecting future survivors. And while this might not be the justice that you sought, I do believe the changes in how we now treat sexual abuse on campuses and in courtrooms alike is a form of justice that will have a profound impact for generations to come. So with that, happy to answer questions. And for the questions that I'm not able to answer, I would throw those to Danielle Hageman-Clark, who's the head of our criminal bureau and who worked tirelessly along with her team on this case and is infinitely familiar with everything that happened here. So.
Great, thank you. Ed White from AP News. Will you unmute yourself, and then please, we ask that you mute yourself again when you're completed.
Diana?
Yeah.
But I just
Yep. Ed, did you hear me?
On about the road.
You should be able to unmute yourself, Ed. Nope. You want to type it in the chat?
Wait, there we go.
There we go.
Attorney General, good morning. I want to ask you, what were your expectations when you got these documents? Wasn't this a possible outcome? You seem to suggest this morning that you and your department were expecting some smoking guns here. What were your expectations, and why is this surprising? Wasn't it possible that these documents would show nothing? What did you expect?
Well, I mean, anything is possible, right? But the way that MSU and the Board of Trustees, over the course of course, many incarnations of the Board of Trustees, the way they were so tenacious in withholding these particular documents, of course, it would lead a normal person to think, well, what is in those documents that they don't want us to see? So, of course, it would lead us to believe that perhaps there was incriminating information that we would find. So, yeah, it was surprising to me that we did not find anything that was incriminating. We found things that were embarrassing to the university, but we didn't find anything that was actually incriminating. And so, yeah, that was surprising. Obviously, we've had calls by countless people, hundreds of people, I would say thousands of people, just to release these documents. And again, let's make it very clear, at the inception of this investigation, MSU pledged to be completely transparent and to provide all the materials that they had. They're the ones who asked for this investigation, right? So, of course, for them to have fought us in court, to have fought us continuously, again, over the course of 2 consecutive administrations and many, many years, to do anything and everything they could to not provide these documents. Yes, of course, we thought there would be something incriminating, and it is a surprise that there is not.
Well, if I can follow up, we had the gymnastics coach who was prosecuted for not following up I think back in the 90s. Dr. Strample was accused of not being very aggressive in following up or enforcing agreements. The FBI dropped the ball. I mean, it seems like we do have evidence of people failing in this multi-year saga. Is that enough? I mean, or do you still feel that there is some institutional responsibility that you just can't seem to put your finger on?
Yeah, I mean, I'm a prosecutor, right? So what we do is, when there is evidence of a crime and we think that we can prove a case beyond a reasonable doubt, and there is the evidence and the facts and the law to sustain that, then we charge. If there's not, then we don't, right? There are other questions, of course, that people would like answered that maybe there is no criminal genesis behind, but maybe there were failures or lapses in the system. And we had hoped, of course, to be able, at least from a reporting mechanism, to lay out what those failures were. And I think that we've done that to some degree. And certainly, as you've indicated, there have been a number of people that were charged other than Larry Nassar. But it would be nice to know more. This is an incredibly lengthy period of time that Nassar, and of course, as you know, later we charged John Geddard and others, were able to perpetrate acts of abuse, or specifically who allowed that to happen. And it would have been nice to really be able to delineate very clearly who all those actors were that were involved in the event that there were others other than the ones we've mentioned. It seems sort of improbable to us, right? This is a major university, obviously extensive number of employees that work there. And yeah, I guess the expectation is that we would find a little bit more than we did. But all I can tell you is this. We assigned our best and brightest to this. They've worked tirelessly in reviewing, again, hundreds of thousands of documents, electronic documents and paper documents, and conducting countless interviews. And I feel like we gave this investigation everything that we could. So we've answered as many questions as we possibly could. Is it enough? Probably not. It's never going to be enough. And we can't, make whole the lives of people who were torn apart as a result of not just Larry Nassar, but the failures of Michigan State University. But I can tell you that we tried our hardest to do as much as we can with the information we had.
Thank you. And just a reminder, we do have 50 people on the call today, and we have 9 additional hands up. So if you have follow-up, which I understand happens, please just raise your hand again, and we'll call on you in order. Matt from Lansing State Journal.
Yes, thank you. These documents had previously been reviewed by 54B District Court Judge Ball, who's no longer on the bench. He found that the attorney-client privilege had been rightly cited. Do you have any comment on his review in light of what you said today?
I have a disagreement with courts all the time on their rulings, right? That is not an unusual set of circumstances. I would say respectfully to the retired judge, we believe that many of the documents that were withheld as attorney-client privilege were withheld improperly. And, you know, what we're going to do, of course, is to release these documents. There will be, of course, redactions that are mandatory on our part, but, you know, we're going to be releasing documents so that you can see exactly why we came to that conclusion. And I know many of the things, and I'll just sort of give you a little bit of a list of examples of what some of the documents reviewed, and many of these documents we reviewed were related, again, to related issues to the investigation, but not things that would have assisted us. And I'll give you an example. Some of them had to do with public relations strategy or preparations for a United States Senate hearing, media responses to university donors, criticism of the pending investigation, business emails that were sent from personal email accounts instead of official MSU accounts, and criticism of the former AG's team and former Ingham County prosecution. So many of the documents were just, you know, they were inconsistent in their redactions, or they applied the attorney-client privilege to the entirety of the document instead of redacting just portions that were regarded to be privileged. So that was our finding. And again, these documents can be FOIA'd, so you'll be able to sort of be the judge of that yourselves when you review these documents, should you FOIA them. It is our intent eventually, of course, to get all of the documents that were reviewed during the course of this investigation online, but that will take some period of time. So we're working on it right now. We're in the steps of setting up an open online portal so that literally anyone can access the complete redacted documents without even having to go through FOIA. But with over 550,000 digital pages and an untold number of paper documents that need to be reviewed and redacted and made accessible, this is a process that can take a little bit of time. So the set of 6,000 documents that were withheld, that's ready for FOIA release today, and credentialed media outlets can request them from our AG press team, and then we'd ask that anybody else go through the formal AG FOIA email. So when you're asking yourself, well, were these properly withheld or not, you be the judge of that.
Great. Owen from the State News, please.
Yeah, thank you so much. I was going to ask you, you had mentioned that there was some embarrassing information. I think you sort of already covered that, but if there was anything else you would like to mention on that front, I guess here's an opportunity to do so.
Yeah, I guess that's what I would say is I welcome you to FOIA these documents. There are things in there, like I said, that weren't really directly related to the investigation, but we felt they were just sort of embarrassing, and that's why the university didn't want to release them. But you'll be able to go through each and every one of those and see what we're talking about, and you can, you know, agree or disagree with us, but we definitely believe that most, if not all of these, were really not truly attorney-client privilege.
Got it. Thank you.
Thank you, Owen. Anna? Michigan Advance?
Like on an annual basis. In the first.
Sorry, did I not unmute myself? Anna from Michigan Advance.
Okay, I unmuted. I'm so sorry. Attorney General, you mentioned the additional trauma this dispute between your office and MSU has had on survivors, given that it's been 6 years. Given that the MSU investigation was cited as one of the reasons that a U of M investigation into Dr. Anderson would not be feasible, how can the state prevent something like this happening again? The struggle to bring these documents to light, and as you are saying, via an improper usage of attorney-client privilege.
Well, that's a good question. I mean, I guess it would take, legislative changes that would provide us with authority that we don't have right now. One of the things we talked about, I will say on a different subject, but semi-related, was our ability to investigate or not investigate what happened in Oxford, right? There have been multiple calls for outside agencies to investigate. I made that offer myself or my department, I think on 3 different occasions, and Oxford Public Schools turned us down. And I had to relay to people, and I know it's surprising to people, that we don't have the authority just to go in and take a look at everything absent probable cause that a crime was committed. And that, of course, remains true. And it's not just that a crime was committed, but also that there is a prosecutable offense. So in the case, of course, of Dr. Anderson, he had been long dead. There would be nobody for us to prosecute that we had probable cause to go in and investigate. So absent that, we didn't have the ability or the authority to, get search warrants or to go in and to perform an investigation. So I would suggest that it would take a change in law in terms of what the authority of the Attorney General is or isn't. And I know when we explored that for school shootings, I think we, and again, please check this and verify that what I'm giving you is correct information. But I think my understanding was we had looked at some place like I think New York, and the New York Attorney General had specific powers and authority by statute that the Michigan AG didn't have. I think it would take something along those lines for us to be able to do an investigation where, certain documents that were withheld could no longer be withheld. And what we do in our regular investigations, by the way, is where we think we're going to run into attorney-client privilege, because under any set of circumstances, we're not permitted to review those communications. We set up a taint team so that the information we're getting in, one pair of eyes from multiple different lawyers, look at that, and then they only pass it over to the investigatory team if those communications can't be properly withheld via either attorney-client privilege or some other type of privilege. So we would do that irrespective. But of course, in this case, we were really at the mercy of MSU to make that decision, and then later Judge Ball in terms of making that decision. I don't know if that helps answer your questions, but again, the attorney-client privilege stuff, we'll never be able to look at that. That is the law, and I would suggest to you there's good reasons for that. But in this case, what made it different, of course, was that we feel as though a lot of those emails were, firstly, withheld from us improperly, but secondly, it was MSU that asked for the investigation, and they told us they were going to fully cooperate. And the implication was we're going to turn over everything to you, including anything that's attorney-client privilege, because we want to be so transparent. And that was the commitment they made initially. And that's why we were so upset that they refused to turn those over, because they told us they would in the first place, and they're the ones who asked for this investigation.
Thank you, AG. Andrew Miniger, you're up next, but let me let in Zach Harmon so that way we don't have the mute situation real quick. But you can go ahead and unmute yourself, Andy.
Thank you, Attorney General. Andy Miniger, MERS News. I'm wondering if the Attorney General's office will be seeking any consequences, or if there's any consequences that can be done for the improper kind of hiding of the or withholding of those documents behind the attorney-client privilege. Is it sanctions or anything that could be put on MSU that the office is seeking?
There's no legal requirement. Yes, of course, we believe that they were improperly withheld, but they did undergo a court review. And again, for reasons that you'll see when you take a look at the emails, and I welcome you to talk to other legal experts, right? I mean, there were many attorneys in our office that came to the same conclusion. But again, they weren't required to give them to us in the first place. We thought morally and ethically they had an obligation to give them to us. But they were not illegally withheld. So there are no legal sanctions of any sort that we could possibly seek.
Thank you. Kara Berg with the Detroit News.
Hi, Attorney General. You said earlier that you learned not all of the communications were preserved. Why do you think that? And do you think that any incriminating evidence was destroyed?
Yeah, I'll let Daniel Heckman-Clark follow up if I'm not answering this properly. But my understanding is that Luana K. Simon said herself that she had been deleting communications. So what are we left with but to believe that she deleted things that possibly were related or important to the investigation when we found those communications of her saying that she had been deleting things? Danielle, do you want to follow up?
My apologies, AG. My computer was getting ready to shut down, and so I had to jump to my phone. I think I understand the question to be the communications and email that we found regarding former President Simon. She acknowledged.
If I could just say this, Danielle, the question more fully was, why do we think that there were communications that we don't have now and that no longer exist? And so I brought up Luana K. Simon as an example of that.
Yeah, so that's right. We found emails where she acknowledged that she, up until she was advised by general counsel specific to our investigation, that she was routinely just deleting text messages. And that wouldn't have been until, January of 2018, long after, the news hit about the sexual abuse by Nassar. And so any of those communications are gone. They were never preserved to begin with. And so that's what makes us believe that there were additional information out there that would have been relevant to our investigation and that they were deleted.
Thank you. Maggie with NBC.
Hi, Attorney General, thank you again, and thank you for your patience throughout this. For those sitting at home and they're just looking at this as one big kind of almost maybe confusing with lines blurred between different investigations and different sort of, judicial bodies, and they're thinking, what's next in this investigation? What's left to be answered? What's next for your office as far as possible criminal charges tied to the Nassar case? They're just outraged by what Nassar was allowed to do and by what he did. What would you tell them? What next steps lie ahead? What questions have you not answered that your office would still like to answer pertaining to possible charges, be it against administrators MSU or likewise? Just how would you explain it to people sitting at home and they're just, again, this to them is just outrageous on all fronts, and they're trying to kind of keep this straight, and where do we go from here?
Well, I would say this. First of all, I believe that in accordance with all the documents that we've reviewed, anyone who could have been charged, where there was sufficient evidence to do so, was already charged. I would want folks to keep in mind that for many non-criminal sexual conduct related charges, there is a 6-year statute of limitations. And that's, frankly, just to add to what I said earlier, I had sort of suspected that maybe the reason they withheld these documents for 6 years, and it was sort of exactly 6 years, right, was maybe they were waiting for the statute of limitations to run, and then we would find additional evidence of crimes that we were barred, we were prohibited from bringing. No, we did not find that. So I would say that, again, we charged everyone criminally that we had evidence to charge. So in terms of moving forward, we are closing this investigation. We don't think, at least for the Department of Attorney General, there is more for us to do except for to release the full quantity of all the emails and other communications so that everyone, so that the world has access to those documents. But beyond that, that's why I really tried to talk a little bit about as unsatisfactory as the conclusion of this case might be for some people, for many people, for us, I wanted them to see sort of the upside of the work that they have done, and so that they understand, the survivors of this horrific abuse understand they have made such a monumental difference. We really look at sexual assault cases differently, I would say, in the entirety of the United States, if not perhaps many places globally as well, based on the work that they did in terms of bringing this matter to light, bringing attention to this. One of the things that I found so amazing was in our work on cold case homicides, our SACI cases, sexual assault kit initiatives in counties all over the state of Michigan, and also in our department. We had survivors who were afraid to prosecute their abusers, but after the Nassar survivors came forward and were as brave and courageous as they were, these other survivors decided to move forward on their court cases as well. And we took, serial predators, serial rapists off the street, in part because of the ripple effect, because of the bravery and the tenacity of the Nassar survivors. And then I named all of these other changes in the law that we've seen. And of course, separately, now we're seeing some pretty significant consequences, I think, with the FBI investigation, which I think we all understood was mishandled in a significant way. So I think that the consequences of what happened at Michigan State University, this will be something that is talked about for a very long period of time, and these survivors will be admired by many for years, decades to come. We'll remember what happened here, not just because of the horrific acts of Larry Nassar and others, but because of how the survivors banded together and made substantive change all over the country.
Thank you. Megan Bunchman, I apologize. Can you say what outlet you're with as well when you start your question? Megan, it shows you as unmuted, but we can't hear you if you're speaking. Nope. Oh, if you want to type it in the chat if your unmute isn't working. And then Owen with the state news, I have your hand still up. Is that a mistake or do you have a second question?
That's a mistake. So sorry about that.
No problem at all. Okay, well, thank you guys all so much. Seeing no other hands raised for your time. If you have any follow-ups that you can think of, oh, hold on. Megan does have her question in the chat, sorry. Has your office reached out to any of the more media-facing survivors about your findings today? And if so, what were their reactions?
I will say that we had a meeting last night with approximately, I would say, 40 survivors and their advocates, because we wanted to make sure that they heard this first from us before it was in the news. And I know that meeting was over an hour. We tried to answer every single question that we possibly could. So we did convene that meeting last night. And obviously, we have a very victim-centered, trauma-informed approach that we use. That's another thing. Again, that's just changed substantially, not just for our department, but for prosecutors' offices and investigatory agencies all over the United States as a result of this. And we're going to continue to have those lines of communications open so that we can answer as many questions as these survivors and their advocates continue to have.
Thank you. And then Sean Lay, last question with WDIV.
Before you go, AG, real quick, thanks for the time. So just boil it down for us, a headline on this. You fought to get the 6,000 documents. MSU held that up for years, and there wasn't anything really in them. That's the headline. The other question would be about deleted text messages. Just to help us understand, deleting those text messages at the time were not a crime?
Danielle, would you like to handle that?
Sure. I don't think deleting the text messages are a crime even today. They certainly weren't back then.
Got it. Thank you.
All right, thank you everyone for your time. If you need a copy of the video, give us probably 30 minutes or so, but email AG Press and we can get this over to you. If you have any other follow-up questions, also AG Press. Thank you so much. Have a great day.
Thanks, everybody.